Right, so what I'll do is I'll go with you through the changes, the lis pendens rule, specifically the relation between lis pendens and the forum clauses. Right, so this rule is basically in its structure the same, all right? Namely that if there are two courts, parallel proceedings, it's the first court that takes precedence. That basic rule stays the same. All right. We also still have the same way of finding the court that is first. And that I've already referred to this morning. That's this Article 32 that tells us, well, in order to know when proceedings were instituted, we have to look either at the time of service or at the time of lodging the proceedings with the court. That depends then on national law, which of those two steps comes first. All right, so that's still the same. Fine. Now, what is interesting is this new Article 32.2. No, sorry. No, that's not what I wanted to say. I'm sorry. The issue that you can ask the court, you can ask the other court when the proceedings were started. And the court must then answer when the proceedings were instituted in that court. Okay? So, it makes it easier. It is an extra reason, it's an extra rule of mutual trust. So, there are proceedings, and you're not sure, okay, which court was first, because you're not sure in the other country what was first, the lodging, the service, when was it lodged at the court. You can, through direct communication, ask the other court, and that's exactly this kind of thing for which you need the EJN to get direct communication with the other court. Right. Here it is. That's 29.2. All right. Inform the former court of the date when it was seized in accordance with Article 32. Right. So ask the other court, and the other court answers you immediately. Right. Then, what else is new is this, without prejudice to Article 31.2. Now, this is the reversal of the Gasser case law. Professor van Kalster referred to the Gasser case, in which the whole issue of mutual trust was very much underlined by the Court of Justice. So what happened was there was a forum clause in favor of the Austrian courts. One of the parties then instituted proceedings in Italy. Okay. The other party subsequently instituted proceedings in Austria, the chosen court. Then the Austrian court was faced with a dilemma. Okay, we are the second court, so under Article, what is now 29, which was then 27, we have to wait. But we do have jurisdiction on the basis of this forum clause. Okay, so it was faced with this dilemma. And the Court of Justice said, well, the lis pendens rule is a general rule. It says that the court second seized must wait until the court first seized has ruled on its jurisdiction. And the court said very explicitly, well, there is no exception for forum clauses, okay? Because that, without prejudice to Article 31.2 and Article 31.2, wasn't in there, okay? So, this meant, okay, on the basis of mutual trust, dear Austrian court, you must know that Italian courts are also capable of reading forum clauses, and they're also capable of declining jurisdiction on the basis of those forum clauses. So just wait, and they will do it. Okay. The case was very much criticized because of the time delays that could cause. You first have to litigate in the non-competent court to go and say, yeah, but actually we want to litigate in the court that we've chosen in the first place. So very soon after the judgment, the Commission has said, okay, but you know, this is really one of the issues for the recast. We have to look into this matter. Then an Italian professor, an Italian author, came up with the words of the Italian torpedo. He then said, okay, well, this case gives us the perfect opportunity to torpedo cases. So what you do is, whenever there's a forum clause, you go and institute proceedings in a court which will not decide quickly, and then you have a few months or some time. People have also spoken about the Belgian torpedo, so it's not only to criticize the Italians. You institute proceedings in a non-competent, slow court, and then you have some time, and then, you know, maybe later your problem goes away. So the Commission said, all right, let's change this without prejudice to Article 31.2. So that means we should go and look then at Article 31.2, which says that without prejudice to Article 26. Now, Article 26 is about voluntary appearance. Okay, I'll get back to that. Where a court of a member state on which an agreement, as referred to Article 25, confers exclusive jurisdiction, then any other court shall stay the proceedings until such time as the court seized on the basis of the agreement declares that it has no jurisdiction under the agreement. All right, so let's take our Austrian-Italian case again. It's an Austrian party and Italian party. They have a forum clause for the Austrian courts. One of the parties institutes proceedings at the Italian court. In this particular case, then, under the new rule, the Italian court would not be in a position to first decide its jurisdiction. It is up to the Austrian court to first decide. All right, so the parties can then go off to the Austrian court, and the Austrian court is the court which is in the position to examine the validity. Now, as we've heard before the break, validity has two aspects: the formal validity, which is exclusively regulated by Brussels I, and substantive validity, which is regulated by the law of the chosen court, including its private international law rules, right? So it's up to the Austrian court to determine, is this a valid clause? Is it in writing? Is it a practice between the parties? Was there any issue of consent between the parties? All of that the Austrian court will decide. If it decides, okay, this is a valid clause, then the Austrian court has jurisdiction and the Italian court declines jurisdiction. If the Austrian court says, no, this is not a valid clause, it refuses its jurisdiction, and then the Italian court can carry on with the case. Okay. So, Italian torpedo solved, no? Several problems are still hidden here, or apparent. One of them is, how long must the Italian court wait for these parties to go to the Austrian court and address the issue? How long? You know what's going to happen. In the initial proposal, the Commission inserted a time limit, saying, okay, the parties then get the opportunity to go and institute proceedings in the Austrian court, and if they don't do so within, I think it was 6 months, then, okay, the Italian court can go on. Right, now that's taken out. That's one problem. The other problem is the reverse can happen now, no? So you can... A party institutes proceedings in, let's say, Austria. The other party then says, no, we have a forum clause, remember? I told you on the phone. I sent you an email, didn't you get it? And which court can now decide on the validity of that clause? Even if it's clearly invalid, it's up to the Italian court. So, the Commission addressed the problem, yes. It did. But I don't think that you could ever take away all forms of abuse as long as the lis pendens rule is as strict a rule of priority as it is today. Okay. Because in the in the Brussels I logic, the first court is first. Well, in the common law logic, you would look at the most appropriate court. Okay, you would add some discretion to estimate which is the most appropriate court. Okay, that is on the relationship between forum clauses and lease pendens. Now, there is another interesting part of Article 31, and that's this one, saying that if it is, so that's Article 31, 4, saying that this whole rule of the reverse priority, if I can call it that, does not apply with respect to weaker parties. And with weaker parties, we mean insurance, insured parties, consumers, and employees. Okay, so whenever they are concerned, and they are the first ones to bring the action, and then the counterparty says, no, but we have a forum clause, remember? If that forum clause is not valid, then this reversal of priority doesn't apply. Great. Valid under which law? Valid under the formal validity requirements as in the regulation, and valid under the law of the forum, including its private international law rules. Okay. So for this issue, they have inserted an exception for clearly invalid rules. But when it's a B2B contract, there is no exception for clearly invalid or abusive allegations of forum clauses. Okay. Then, the other interesting part is this new rule, which I've already referred to, which is courts in third states. Okay, this is new, and it shows some opening towards third states, saying that if the third state court was seized first, then we can decline jurisdictions in a limited number of cases. Firstly, jurisdiction must be based on one of those provisions, so not forum clause, not exclusive jurisdiction, not voluntary appearance. And then you may stay the proceedings and decline jurisdiction. It's discretionary, it's not an obligation. And then what does one consider is the potential recognition of that judgment. Now remember, the recognition of a judgment of a third state falls also outside of the scope of Brussels I. So for that purpose, you would have to look at your national law, whether there's a bilateral treaty or whether that judgment would presumably come under the rules for recognition and enforcement. Then also this one, a proper administration of justice. That's also interesting, a sort of very discretionary basis that you can consider. Now, I think it is this that Geert van Kalster refers to when he says that one can take into account whether there is a forum clause for the third state court. Okay, that would, I think, come into a proper administration of justice. However, you can only use this if the third state court was first. Okay, if proceedings were brought in a member state court first, there's no way you can use this, and there's no way that there would be any reflexive effect, to my mind. Oh, and it's all of a sudden bigger. Okay, that's great. A bit late, though, because that was the most important things that I wanted to say about the new lease pendens rules, unless you have any questions on that. Yeah? Wait a minute, I can't hear you. Yeah.
Do I understand this correctly, that it requires, 33B requires you, or possibly requires you to write that you, in your decision, that you think that the third state X does not properly administer justice. I'm not really keen on this phone call from the Foreign Ministry, which I'll receive the next day. Is this going to work in practice?
That's a good question. The proper administration of justice, how it's been used, for instance, in Brussels 2 bis, more refers to particular circumstances. For instance, I've seen cases under Brussels 2 bis where they would refer to the need for a quick decision in the interest of the child. So I think it would be more, you wouldn't necessarily refer to a proper administration of justice in general, but a proper administration of justice to these parties in these particular circumstances. They have been litigating for a long time, the evidence is here, the assets are here, more practical issues like that. I would say rather in the specific case than saying, well, that's a banana republic. I don't think that would be a good idea to write that in your judgment, no.